11081-DE. If I can have the attorneys place their appearances on the record, please.
J.D. Prospect on behalf of Diane Gilpin.
Thank you.
Good afternoon, Your Honor. Rebecca Haynes appearing on behalf of the personal representative, Kevin Mercer.
Do we have all the parties, counsel?
Yes, Your Honor.
All right, this is a motion for summary disposition, I believe filed by Ms. Gilpin. Mr. Prestrink, you want to argue your motion?
Other way around, Your Honor.
I apologize. Sorry about that.
No problem.
Go ahead.
Good afternoon, Your Honor. This is respondent's motion for summary disposition as to the petition to invalidate the will. This is brought pursuant to Michigan Court Rule 2.116C10. Petitioner Diane Gilpin has alleged a count of lack of capacity and another of undue influence in her petition. The reasons stated in our brief and at this oral argument, we believe that she has failed to sustain her burden of claiming either burden of proof on either claim. Specifically, there's absolutely no evidence that decedent lacked
The heart transitions are SG, and we all know it.
testamentary capacity on December 7th, 2024, when he executed the most recent will and deed. Furthermore, there's insufficient evidence to support petitioner's allegation that decedent was unduly influenced by anyone, let alone respondent Kevin Mercer. Discovery in this matter has closed on back in December of 2025, and no such evidence has been presented to date, either throughout the course of discovery or in response to our motion. The decedent, Joseph Laszlo, was a 96-year-old man who discovered that money was being taken from his accounts by his daughter, petitioner Diane Gilpin, without his knowledge or permission. He consulted his attorney, he reviewed his records, and he decided to change his estate plan to cut out his daughter. Petitioner now asks that this court reverse his wishes. Petitioner again bears the burden on both of these claims. Specifically with respect to testamentary capacity, that is presumed. She has to show that at the time the will was executed, that he lacked testamentary capacity. At the time the will was executed, it was the individual who drafted this will, attorney Jean Michalak-Weiss, was present with decedent, as outlined in the facts as well as my reply brief. The will was read aloud to decedent. He understood at that time everything that was happening with the will, and he agreed and he signed it on that date. Previous to that, he had had several discussions with his attorney, which she testified to, that he did not want everything to be left to Diane, that he wanted to change his will, and he expressed how he wanted to change his will. Additionally, the primary care physician for decedent had stated that he did not believe that there was any issues with his capacity. The neighbor who was also present at the time the will was signed did not believe that there had been any memory problems or any reason to suggest that he may have had difficulty with his mental faculties. There's absolutely no evidence that he was suffering from dementia or any concerns thereof. There's no medical records to support that, and there's no testimony to support that. Again, these are the individuals who were with decedent in the last several months of his life. With respect to the presumption of undue influence, a presumption does arise if there's a fiduciary relationship. However, in this case, none existed. The respondent in this matter, Mr. Mercer, was not in a fiduciary relationship with the decedent. Respondent falsely claims he was power of attorney. That's not true. He was never the financial power of attorney or durable power of attorney. He merely had power of attorney with respect to health care, and that was only if decedent was unable to make his decisions. Again, the will change was decedent's independent, autonomous decision. He knew there was something wrong every time he went to go to check on his to the bank, he noticed more and more money was missing. This led him to have a suspicion to ask the bank to give him his records. When he obtained the records, he asked several people for assistance, ultimately meeting with his attorney several times. His attorney specifically testified that there were several transactions that she believed were egregious. This isn't a situation where seeds were planted in his head. There is direct evidence, both through testimony and through records, that money was being taken. And decedent was reasonably frustrated. There was absolutely a reason for him to be frustrated. Everybody, including his own attorney at first, did not believe that money was being taken. But once the records were reviewed, it was very clear. And at that time, decedent became very frustrated and he wanted to change his will. Again, this was discussed with several individuals, as we outlined in both our brief and as well as our reply. He was extremely clear on his wishes, again, testified to by his attorney. And again, respondent here lives in Adrian, which is approximately 3 hours away, if not further, from where decedent lived. It's just, there is no question of reasonable fact here. No jury is going to determine that an individual who lives that far away, who is not with decedent on a daily basis, who didn't handle his financial affairs, had the ability to overcome his direct decision making and his willpower to change his will to in this matter. The decision was completely Mr. Laszlo's, or the decedent's, on his own, and he made that deliberate decision. Therefore, for the reasons stated today on the record, as well as in my brief and reply, we would request that this petition be dismissed with its entirety and with prejudice.
Thank you, counsel. I have a couple of factual questions before I turn to Mr. Prastrink. There was submitted in materials from one side or the other a will dated 12/27 of 24. It's my understanding that you are saying that the will that you wish to have used is dated 12/7 of 24, not 12/27 of 24. I believe it was 12/27 was plaintiff's exhibit or petitioner's exhibit number 12. Why the difference in the dates? Was that simply a mistake on the writing of it, or what was the deal there?
It was a mistake on the writing. It was testified by both the attorney as well as the witness, Ms. Cheryl Goff, that they were there on the 7th and witnessed decedent sign the will.
So there's no subsequent will. It was all signed on December the 7th, and there was no subsequent attempt to make a different will of any kind on the 27th.
No, Your Honor, there was just the will signed on December 7th of 2024.
All right. And then to make sure I understand your argument as to undue influence, you mentioned that there was no fiduciary relationship. Was there the durable power of healthcare, was that signed at the same time as the will on December the 7th?
Yes, Your Honor.
So leading up to that will signing, there was no other power of attorney of any kind between Mr. Mercer and the decedent?
No, Your Honor. And that
right.
is the only power of attorney. There is no other durable power of attorney.
All right. Thank you very much. I appreciate that. Mr. Prastrink, your response?
Thank you, Your Honor. I apologize ahead of time if I get too excited in this argument. Before I forget, just to clarify, the fiduciary duty or fiduciary relationship is not dependent on a power of attorney. So one can exercise that relationship de facto, which happened here without a durable power of attorney for finances. Now, my understanding is that one was executed. If opposing counsel says that one was not, I'm not going to call her a liar, but I would indicate that you do not need a written durable power of attorney to participate in a fiduciary relationship. And as the court can see in our response brief, there was clearly a relationship that formed, unfortunately, between Mr. Mercer and the decedent. Our brief explains in detail the law and the facts supporting the lack of capacity. Respondent wants to limit the determination of the day of, but as the Court of Appeals has clearly indicated, you can look up to, in certain case, 5 years before to see in the totality of the circumstances, for lack of a better term, whether or not the decedent at the time of signing had the capacity to sign the will. Again, as detailed in our brief, he clearly did not. I think it is common sense that you're having difficulty in your cognition if you think that you just fell in a lake and didn't. If you forget that you closed a bank account 2 days ago. If you forget that you actually settled a property line dispute 12 years ago, there's something wrong with your mental capacity. And it was for that reason, with that diminished mental capacity, that Mr. Mercer was able to take full advantage of my client's father. The court heard that there was no testimony to support dementia, and yet my response brief is full of it. And the response brief is only 20 pages, but there are hundreds of pages of deposition testimony that indicate there were issues with Mr. Laszlo's capacity. You can look at my client's deposition for the most details, but it's without and throughout.
I get what he's saying. I do. And it all makes a lot of sense. But I would avoid referring to my own brief as being full of it. It's a poor choice.
About the other depositions. You'll see the court will see in the reply brief that Mr. Mercer the court also heard from opposing counsel today, the continual slander of my client, which I'm offended. I'm sure she is, and I hope the court is. The court will look through the plea.
Mr. Prastrink, let me just tell you one thing real quick about me. I'm not impressed by arguments about what I should feel or how I should feel them. And I don't really care what you feel about things either. So tell me some facts, and let's stick to the facts, please.
So in the reply brief, the respondent's attorney continues the slander of my client by indicating on page 4 of the reply brief, she says things like daughter who took advantage, quote unquote, stealing money. Something was wrong, stealing money again. On page 5, she says, quote, because she betrayed his trust, end quote. Then she says, quote, because of what Diane had done. And the court will not see one fact in the record of anything wrong that Ms. Diane Gilpin did. There was no money missing anywhere in the accounts. Opposing counsel continues to state that. The court won't see any money missing. Attorney Jean Mahalik Weiss told Mr. Laszlo repeatedly that there was no money missing. Mr. Laszlo authorized the reimbursement of travel expenses so his daughter could visit him from Florida. When Mr. Laszlo objected to or brought up this amount of money, this $29,000, his attorney continually corrected him and told him that there was nothing wrong with the money and that he had authorized it.
Mr. Prastrink, I seem to recall a letter from the attorney to your client stating that there were financial, I forget the word that she used, but there were financial issues. So where are you in the record getting these allegations that you're making now?
I would, on that note, I would emphasize and request that the court read our brief very, very well, because the details are spelled out chronologically. So what I say now is not going to be as well as it is written chronologically. But if the court will bear with me, I will go back to the brief and answer that question.
So show me in your brief where it's at.
On page 5, the second full paragraph, it states, in May 2024, respondent told Joe that the CD was decedent's money and that he should get bank statements to see if other money was missing. Respondent also encouraged Joe to retain Ms. Mahalik to make changes to his estate plan. Respondent then started calling Diane and accusing her of taking money from her father. That's when this started.
How does that support your claim?
If the court then turns to page 6 of our response brief.
What on page 6?
Thank you. The last paragraph that starts on July 18, 2024, a telephone conference was held with Joe, Ms. Mahalik, Diane, and Doug.
I
Ms.
read
Mahalik
that
told-
paragraph. I see no citation to any factual basis. Where in the depositions, where in the submitted documents do I find corroboration of that?
Diane Gilpin's deposition testimony.
Where? I don't see it cited anywhere. When I tried to find it myself, I couldn't. In addition to that, when I compared it to Ms. Mahalik's testimony in the deposition, she denied that Diane did nothing wrong regarding the expenses. So I've got, at best, I've got your client making self-serving claims about that issue, that there was no financial issues going on. I've got the attorney who changed the will for her one time and against her another time, saying that there were financial issues. So where are you? Go ahead, sir.
Yeah, as the court will see in a chronology again on page 6 and beyond, what happened was Ms. Mahalik reiterated to Mr. Laszlo that there was no missing money, that he had authorized the reimbursement of the travel expenses, that this account was a joint account owned by Diane Gilpin. And that's not apparently acknowledged in any of Mr. Mercer's pleadings.
Where is that found in Ms. Mahalik's deposition?
Okay, I'll switch to that. I have the transcript of Ms. Gilpin's deposition pulled up. I'll keep that up. I'll move over to Jean Mahalik's. I'm sorry, could the court repeat the question about Ms. Mahalik?
Yeah, you said Ms. Mahalik told your Mr. Laszlo a number of times that there were no money missing. Where is that found in Ms. Mahalik's deposition?
It's not there, Your Honor. That's the alarming part.
You're right. That is an alarming part for you. Why would that be? I don't understand what you're trying to claim then.
Well, Ms. Mahalik said one thing to Mr. Laszlo. He said, Joe, you authorized this reimbursement of travel expenses. I've looked at all of the travel expenses. They're legitimate. And then she says to Diane.
Who claims that she said that they were all legitimate? Who claims that?
Diane Gilpin, Your Honor.
All right. So your client says that Ms. Mahalik said one thing. We get Ms. Mahalik to the deposition and she says the absolute opposite.
Correct.
Why is that a lie on Ms. Mahalik's part? Why isn't it just a self-serving statement on your client's part?
Well, because the truth is the truth, Your Honor. That's why.
So I've got two diametrically opposed things. I've got one party in interest. I got one party does not have an interest in this case. Which one am I supposed to believe?
Well, that's a genuine issue of material fact. The court has to determine credibility.
All right, go ahead, sir.
Thank you. So as part of that chronology and order, after she indicated that all the expenses were legitimate to Joe, he then got upset. And again, this goes on and on in our statement of facts, which is long for this reason, so that the court knows what was said when. Then she changes her mind at some point when Joe was not getting the response that he wanted from Ms. Mahalik. He then threatened to fire her. At that point, she then writes a letter to Ms. Gilpin and says the exact opposite as the court observed from what she had said before. I'd also point out that Mr. Mercer is good friends with Ms. Mahalik.
Mr. Prastrink, is it true that Ms. Mahalik did the will change for your client from on April 9th of 24?
Yes.
And isn't that before Mr. Mercer got involved in this matter?
Yes. Well, I shouldn't say that. No, she prepared the will because he wanted a new will. So no, he was involved before.
This is the will. 4924 will is the will that left everything to your client.
That's correct.
Didn't she, Ms. Mahalik, drafted that will?
Yeah, but she got her name, Ms. Gilpin got the name from Mr. Mercer. She didn't know Ms.
Apparently she knew her well enough to say, go ahead and draft a will for me that leaves everything to me.
Ms. Mahalik, let me back up. Mr. Mercer recommended Ms. Mahalik to Diane Gilpin and said, does your dad have a will? So then Diane Gilpin, who didn't know Ms. Mahalik at all, said, well, I can schedule an appointment. So she schedules an appointment, shows up. Then Ms. Mahalik has another appointment with Joe without Diane, and then drafts the will. But no relationship before Mr. Mercer.
So it depends
Still,
on how
she's
you
using
define
that
it.
same attorney to draft a will for her that ultimately benefits her 100%. The will previous to that was in November of 23, and she only had 85% going to her. 5% was going to each of the three sons at that time. So how am I to conclude that there's some undue influence between Mr. Mercer and Ms. Mahalik if your client's one that used that same attorney to draft a will that went in her
He's not perfect, but this judge is damn good. He's got a good BS detector.
favor?
Well, just a couple of things. One, Ms. Gilpin did not retain Ms. Mahalik for the will. It was Mr. Laszlo. And also, again, the undue influence is extremely obvious if you look at all the facts as laid out in the response brief. So on that note, okay. On that note, let me go through that. I just want to make sure the court knows where I'm coming from here. So on page 14 of our brief, we explain undue influence.
Yep.
Okay, so a presumption of undue influence arises if the evidence establishes the existence of a confidential or fiduciary relationship between the grantor and the fiduciary. The fiduciary or an interest which he represents benefits from a transaction, and 3, the fiduciary had an opportunity to influence the grantor's decision in that transaction. So in this case, Mr. Mercer satisfies those 3 elements, and a presumption of undue influence would arise.
Tell me specifically how he satisfies those 3 requirements. I want to make sure we've got a good record of that.
Okay, so if we go back, this is on page 4 of our brief. In March of 2024, Diane attended Joe's 96th birthday celebration. At the party, Mr. Mercer asked Diane, does my grandpa, your father, have a will? She then told him that her father had just drafted one several months prior. So we've already got a will. Mr. Mercer then says, oh, he should get a new one. And you should go to my good friend, Ms. Jean Mahalik Weiss, to draft it for you.
How does that information get into one of these 3 elements? That's what I'm asking you. I want you to walk me through what facts explain which element. How does what you just said connect to the dots?
Sure. The next thing would be on page 5.
No, tell me what happened on page 4. What were you just told me a bunch of stuff. He asked about a will, said you need a new one. How does that connect to one of the elements?
He's developing a fiduciary relationship and a confidential relationship with Diane's father.
How so?
Well, Your Honor, I mean, if you're going to ask someone to prepare a new, hey, if you go, your dad's already got a will, but you should go get a new one. He should go get a new one. Talk to my friend. That was anyone.
The courtroom goes silent, but the tension is at an all-time high. In a legal battle where millions are on the line, one wrong move can destroy everything. You are watching Law Locked. Stay tuned, because the biggest twist is coming up next.
Would be suspect of that.
You're going to have to do better than that by telling me anybody would, because I'm not. How does that establish a confidential or a fiduciary relationship? And he's not talking to the decedent at this point, right? He's talking to your client.
Well, yes, Your Honor, but I want to be clear for the record, so the record is clear that undue influence, the court would look at the totality of the circumstances to look to see if these elements are met. So
I
in
understand that.
in addition to what I said on page 5, in late April of 2024, this is after the conversation of Mr. Mercer saying, hey, he should get a new will. Then all of a sudden, Joe Laszlo starts accusing his own daughter of stealing a tray of gold coins from a cedar chest and a sock of $50 from his safe. In reality, there never was a tray of gold coins in his cedar chest, and all of his coins had always been in his safe. So we don't have...
Go ahead.
Sure. So we don't have any accusations before, but now we've got accusations. So now Joe is accusing his daughter of doing something wrong. She never did anything wrong up until this point. The court will never...
I still haven't seen any connection between confidential or fiduciary relationship between Mr. Mercer and the decedent.
Okay. All right. So you'll see, let me put it this way. If the court reads the statement of facts, the court will see that throughout these months that are going on, Mr. Mercer is spending more and more time with his grandfather. During the times he spends more time with him, the following days, he will start accusing Mr. Lazarus, accusing his own daughter of doing things wrong. You broke my porch.
How do you know that? What proof do you have of that he got that from Mr. Mercer?
Oh, we don't have proof that he said these things or what was said during the weekends. We do not know. What we do know is what happened.
So you've got Mr. Laszlo, the decedent, accusing your client of stealing from him, but there's no connection of any of that information to Mr. Mercer.
Entire connection, correct. So if there's no allegations of any wrongdoing, and then your father starts spending time with a third party who before then did not have this relationship, but starts to spend more once he finds out that there's a will involved. And then following this time spent, there are allegations coming from your father, whom you've known your whole life. You know that there's some connection between why is he alleging things. And again, I want to repeat to the court will not see one thing wrong that Diane Gilpin did. So there's no basis for Mr. Laszlo accusing her of doing anything wrong because there isn't anything that she did wrong. But for some reason, after he spends time with Mr. Mercer, he starts accusing my client of doing something wrong.
How do you know that this happens after he spends time with Mr. Mercer?
Again, it's explained in the brief, but because my client testified to that.
That's what I'm asking. How does she know? Because she didn't have any contact with her dad after, May of 24, and only had maybe phone contact up until October of 24. How does she know this? I know what she testifies to, but how does she know that?
Does the court ask me how she knows when her father spent time with Mr. Mercer?
Yes.
She talked to her father.
Where's that in the depth?
The pages, it's 94 pages, Your Honor. It's all throughout it, I promise. I mean, I can, if the court wants, I can look through it now.
Let's assume for a minute that what you tell me is accurate and that there is a connection between Mr. Mercer being at the house and talking to the decedent and the decedent then making allegations against your client. How does that prove a confidential or fiduciary relationship between the decedent and Mr. Mercer?
Sure. So, Your Honor, if somebody's looking through my finances, and if I say, hey, Kevin Mercer, look through my finances, and he looks through my finances and looks through everything, he knows my assets, he knows how much money I've got, he knows everything about me, there has now been established a confidential and a fiduciary relationship.
How so? Just because I talked to you about your finances, I'm now a fiduciary for you?
I don't want to argue, Your Honor, but it's clearly a confidential relationship.
No, this is the time for argument. This is exactly what this is for. You need to convince me that there is a fiduciary relationship here, and I don't see it. So that's why I'm asking you. I want to be very pointed. I want to give you every opportunity to present your case, but don't just tell me what you know specifically.
It's a confidential or a fiduciary relationship, number one. The law.
All right, so how is that either one of those two things?
Well, if Mr. I don't want to state the obvious, but if Mr. Mercer is looking through Mr. Laszlo's finances and his checkbook and his bank accounts and is looking at his CDs, if he's looking through his finances, that's confidential. That's a confidential relationship. That's the definition of it.
Not if he allows it to happen. It's not confidential. If he says, here, take a look at it. And again, how do you know that any of that happened?
Well, he said so.
Who said so?
I apologize, but it sounds like the court hasn't read my brief, and I don't mean that. I just want to indicate.
Sure, I read your brief twice. I've read it twice.
I've
read it twice. So make a record today. Okay. Tell me who said that. Okay,
on page 17 of the brief, the second full paragraph starts, respondent openly admits to beginning financial discussions with decedent in the early summer of 2024, and also openly admits that he impressed upon his grandfather that, quote unquote, something wasn't adding up. Kevin Mercer testified at his deposition, quote, so the only thing I could say is that I had recommended early on, I would say early on being in May or June of 2024, that he speak with Diane, because my natural assumption was that there must be a misunderstanding. I just felt like, maybe there's just something that's not adding up here that he would need to speak with Diane about. So I highly encouraged him. I said, Grandpa, just speak with Diane, find out, maybe there's something that just, whatever, something's not adding up. End quote.
And I read that and I thought, that doesn't sound to me like a detailed financial analysis of anything. That sounds like a grandpa and a grandson having a conversation about grandpa thinks that daughter's stealing from him, and grandson says, hey, grandpa, talk to her. Find out what's really going on. I don't see a confidential or fiduciary relationship there. That sounds like a normal grandpa and grandson conversation when grandpa's upset about thinking that daughter's stealing from him.
Okay. So again, as I continuing on page 17, it states, according to respondent, as they went through the bank statements together, it was, quote, very clear that money was being taken out of his account without his knowledge or permission, end quote. Respondent influenced his grandfather's understanding of the finances in the account. He testified, Kevin Mercer testified, quote, so as he and I went through the bank statements, he would see transactions that were being performed that he realized were not did not come with his authorization or his knowledge, and that was very upsetting to him, end quote.
Okay, so again, how does that establish a confidential, grandpa's showing grandson the bank statements? How does that establish a confidential or fiduciary relationship? Is Kevin Mercer taking any money out of those accounts? Is he doing any financial dealings with it? Is he getting grandpa to take money out and give it to him? Is anything like that benefiting Mr. Mercer at that time?
Your Honor, he inherited the entirety of Mr. Laszlo's estate.
Not yet, he hasn't.
He has the house, he has all his money, he had his car, everything.
That's after the fact. You're saying you're looking at this through the lens of after the fact. At that time, how do I establish that there was a fiduciary relationship then? Because that's the only way this works. I can't do it I can't reverse engineer that from the backside. I've got to find that there was a fiduciary relationship then that he used to unduly influence. That's where the presumption comes in, that there was a fiduciary relationship, and that because of that fiduciary relationship, we can presume that there was undue influence. I can't look and say, well, the will ultimately gave him this, therefore there must have been a fiduciary relationship. That sounds to me what you're asking me to do. I have to see that there was a fiduciary relationship. So I'm asking you to lay it out very clearly. Where is the fiduciary relationship?
Well, Your Honor, I would argue, number one, that I've already demonstrated it and that my brief demonstrates the confidential at least relationship. I would argue that it also demonstrates a fiduciary relationship, and also it also indicate that this is for the presumption to arise. Okay, so even if the presumption doesn't arise, that would still be a legal point or a fact that would need to be established at trial. But yes, as the court looks through the totality of the circumstances, looks through the documents, hear the record before the court, you will see, I would argue that there is a clear confidential relationship. If Mr. Laszlo is doing whatever Mr. Mercer says, that's a fiduciary relationship, that's a confidential relationship. And as the court will see that there was at some point all of the Mr. Laszlo revoked the power of attorney he had given to Ms. Gilpin at some point and sent that to Ms. Mahalik. So she acknowledged that. And so he no longer, for as far as I know, if Mr. Mercer did not have the durable power of attorney, Mr. Laszlo had no durable power of attorney. And the only person that I can see in the record that actually assisted, if not conducted, Mr. Laszlo's finances was Mr. Mercer.
Is that an inference that you're drawing, or do you have some specific documentation or testimony that supports that allegation?
No, lots of specific testimony. You'll see that in the depositions of Ms. Gilpin. You'll see that in the deposition transcripts of Mr. Laszlo's sons. It's in there as well.
And how would each of those know who is conducting the financial business? The sons are out of state, and Ms. Gilpin is the number of hours away from where this is supposedly occurring. How are they to know that?
Well, Mr. Mercer was the one that informed one of the sons, I think it was Joe, that Mr. Laszlo had died. He was making the announcements. He was making the decisions in the hospital. He was providing the notices to everyone. I'm not aware of anyone else. So if there was anyone else, then it has to be Mr. Mercer.
How does providing a death notice show that he was doing financial things for Mr. Laszlo?
I don't think it does, Your Honor.
Well, that was what my question was. How would the sons and your client know that Mr. Mercer was conducting financial business for the decedent when they were states away and hours away and didn't have any contact with their dad directly for months prior to his death?
I want to be clear that I'm not arguing that I have evidence that Mr. Mercer signed checks for Mr. Laszlo. I don't know if what he did that. All I'm arguing is that pursuant to this common law, he had a very clear and obvious confidential relationship with Mr. Laszlo, with the decedent.
If you're satisfied with this record, go ahead and continue your argument.
Thank you, Your Honor. So this case is a prime example of undue influence, that someone that with a lot of craftiness can create this tragedy. And again, if you have a relationship here, a strong relationship between the decedent and Ms. Gilpin, she cared for him. She cared for both of her parents for years. She paid for funeral bills. She paid for travel. She came up often. She took care of her mom. She visited often, very close relationship. And the record demonstrates that that relationship was severed, that when her dad died, her dad was upset with her for things that she never did. It's not that money was missing and we don't know who the culprit is, or that my client is blamed for this missing money. There is no missing money. Mr. Laszlo asked Diane Gilpin to buy the CD. He said, "It's your money anyway." He added her as a joint account holder. Ms. Gilpin owns the account from which she's accused by Mr. Mercer of taking money out of. It's her account. And so this is a tragedy that because of Mr. Mercer's opportunity, and undue influence is not an easy thing to show. As the court will see, there's a lot of work that has to go in to unwind the actions of someone who decides to go in and step into someone else's lives and to take away Ms. Gilpin's father from her. He died without her even being notified. She wasn't notified that he was even in the hospital. So she couldn't go to see him because she was mad at him, or he was mad at her for things that she never did. It's unfortunate that these things happen. This is a clear case of undue influence. Fortunately, our common law has a cause of action for this, and this case fits it. For that reason, we're asking the court to enter summary disposition in favor of Ms. Gilpin, or at least to find that there are genuine issues of material fact that would need to be adjudicated at trial. Thank you, Your Honor.
Ms. Haynes, any response?
Yes, Your Honor. Your Honor, with respect to the undue influence, even going back to, again, the presumption that arises, there is no fiduciary relationship in this case. There's been zero evidence of that. There's no evidence that Mr. Mercer was assisting him with the typical things that arise with a fiduciary relationship, taking him to appointments, doctors, like acting as a caretaker in any way, acting as a personal banker in any way. There is no evidence of that. Second, so he's failed to meet that initial burden. And then again, Your Honor, we are here today on a motion under MCR 2.116C10, meaning that at this point in time, we are requesting that, excuse me, that here, where the burden of proof at trial on a dispositive issue rests on the non-moving party, which in this case is petitioner, that party may not rest upon mere allegations or denials of his or her pleading, but must, by affidavits or otherwise provided in this rule, set forth specific facts that showing a genuine issue for trial. Those specific facts also have to be admissible in this matter, not hearsay. What I've heard in in petitioner's oral argument today was a lot of hearsay that is not otherwise admissible in this matter. So again, back to the issue of undue influence here, the presumption does not arise. And furthermore, again, there's just absolutely no evidence that this occurred. Mr. Mercer lives several hours away. He visited his grandfather maybe once a month, if not more. And again, petitioner is ignoring the fact that decedent was the one who approached Mr. Mercer to ask him for help. He also is completely ignoring the fact that all throughout this time, decedent had independent counsel that he visited on several occasions and that he asked to go over this with, and he asked for his assistance with. He became angry with petitioner. He believed she was stealing from him. Other people were corroborating the fact that she was taking money. And again, this, as to the fact that it's a joint account, she was placed on that account, and she testified to the fact that she was placed on that account for the specific purpose of assisting her father with paying bills, not so that she could spend it however she pleased. She also admitted that she did not put any money into that account. So again, we are requesting that we have summary disposition on respect to the undue influence claim and have it be dismissed with prejudice. Back to the lack of capacity argument, again, it is judged at the time that the deed and the other documents were signed. At that time, his attorney was present. His attorney testified that she specifically went over everything, and she stated that she had absolutely no question in her mind whatsoever that Joe, the decedent, knew what he was doing on that day. Again, the witness as well, his neighbor, Ms. Goff, also testified that he knew what he was doing. He had expressed to her the wishes for this changing of his will several times prior to that. And this wasn't a situation where on December 7th, he decided to change his will. This was over the course of several months. And he expressed this to Ms. Michalak Weiss, I believe it was October 25th. of 2024 that he wanted to go about changing his will. The timing of signing it was just delayed by several factors. Here, petitioner has failed to present any admissible documentary evidence establishing her claims. Again, at this point, it is not a trust me standard or we will present the evidence at trial. This is the time, today is the date to present the evidence, and it's not there. As such, we're requesting summary disposition as to the lack of capacity as well. Thank you, Your
One
Honor.
final bite at the apple, Mr. Prastrink.
Yes, thank you, Your Honor. I just wanted to indicate that, and just reiterate that the presumption of undue influence can arise if there is a fiduciary or confidential relationship. So I'm arguing that that does exist, but even if that doesn't exist, it's not a requirement for undue influence. That it's a process rather than a specific event. That's what the Court of Appeals has held. And so, you have to look at the totality of the circumstances. So I just want to indicate that another way to say this is you have someone, my client, who is who's in a very close relationship with both of her parents. And then she's disinherited. And we have to ask why. Well, what did she do? And if we look at the record, she hasn't done anything wrong. In fact, the one thing that she's alleged to have done wrong, Mr. Laszlo's own attorney confirmed was what he wanted. And so we have to say, well, if we have someone that's been disinherited entirely and given to he didn't give his estate to one of his sons, to a grandson. We have to ask why. There's some reason why. There's something's not adding up here. And that's why this kind of undue influence is important, because it allows us to show that sometimes people use the manipulation. They see someone in a diminished capacity. So again, even if the court doesn't find that Mr. Laszlo lacked testamentary capacity, which I think is clear, but even if not, he was clearly in a diminished capacity. Mr. Mercer found him in that diminished capacity. He took advantage of it, and he was able to walk away with the entirety of the estate. And he was even able to sever the whole relationship between my client and her father, which is a tragedy. And so for that reason, we're asking the court for relief. Thank you, Your Honor.
Mr. Prastrink, let's assume for a minute that a 96-year-old man gets a wild hair and believes, even improperly believes, but he believes that his daughter is stealing money from him. And then a family primary care physician and a doctor in the hospital on the day that he signed the will, the new will, and a neighbor who visited him 5 or 6 times a week or so in the last 6 months of his life, and an attorney all say that he was competent to sign the will. How do I show that he had a diminished capacity such that he couldn't properly do a will?
I think, again, the case law that we submitted as part of the brief, it discusses this issue, and the Court of Appeals said in that case that, forgive me, Your Honor, well, one thing that's important is regarding the opinion of a physician. The opinion of a physician as to mental competency, aside from the question of insanity, is entitled to no greater consideration than that of a layman. That's one thing I would indicate. The other thing is that, somewhere in the brief, we've got a case that says you can look back 5 years before the time. And I think in this case, the court can do that to see these are extreme issues. This isn't you forgot what day it is. This is you think you just fell in a lake. You're dry. There's serious problems going on. And I think that diminished capacity is there. I would also indicate that opposing counsel mentioned that we don't have admissible evidence, and yet she's relying on the same evidence that we submitted to the court. She's relying on deposition testimony from Cheryl Goff, deposition testimony from Jim Hollick-Weiss. We're doing the same. And again, I think that this undue influence, this is, to be blunt, this is a difficult issue. I have not seen a case like this before. I don't think I even saw it in law school. This is something that these circumstances define undue influence. This is when we have someone in diminished capacity, we have someone that employs a long process to unduly influence this person that's in a weakness. So if Joe Laszlo is saying, hey, someone's stealing my money, you say, no one's stealing your money. You told Diane, number one, this is Diane's account equally as yours, and you told her to reimburse herself. She did. Your attorney approved it. Everything's good. But now someone comes in and says, you know what, Joe? Something's not adding up. Well, to someone with a diminished capacity, he starts to be paranoid. And as the court will see from the deposition transcripts of Joe's other sons, he accused them of similar things, of stealing what was it? A waffle maker and a generator. And he said, I didn't take any generator. He didn't even have one. Or, there was two and he said to take one, or whatever it was. But again, this case is why we have the ability to have undue influence. And again, one last, if the court would indulge me, if nothing else, I would indicate that we have to answer the question: why is he disinheriting Diane Gilpin? If Kevin Mercer's not in the picture and he just says, "Hey, you made a comment, you used a swear word, you upset me because you didn't come to my birthday party." Honestly, if you look at the record, Diane Gilpin is a model daughter. She did everything that she could for her parents, and yet somehow she loses her father, who won't even talk to her, let alone the estate. But she loses her father. There's some reason here. Someone did something.
Mr. Prastrink, is not that something the subject of the letter that Ms. Mahalik, the attorney, wrote to your client about the financial issues? Is not
Yes.
that what caused all of this?
Yes. So Ms. Mahalik, again, Ms. Mahalik first says, Joe, there's nothing wrong. Joe, you can offer.
According to your client.
Well, right, but Your Honor, with all due respect, Ms. Haynes is submitting the same evidence that I am. Kevin Mercer's testimony is just as weighty as Diane Gilpin's. And so if Diane Gilpin is testifying under oath at the deposition, subject to the penalty of perjury, that Jane Mahalik says A, B, and C at this meeting, Mr. Mercer would have to find some way to attack that credibility. But if that's the case, and if it is the case, as stated in our brief, that Joe didn't like it when Gene Mahalik said, Joe, everything's fine. And he said, well, I'm going to fire you unless you do something. And then 2 days later, she writes a letter that's 180 degrees from where she was before. Something's amiss.
Assuming that your client is true, or your client is telling the truth, that is one way to look at it. But here's how I try to do things. When I'm looking at who am I going to believe, I tend to throw out the competing interests and say, what do I have without the competing interests that shows me which side may be telling the truth? And I come up with the doctors and the neighbor and the attorney. The doctors, the primary care physician that known him for a long period of time, says he's competent. The doctor at the hospital the day that he signed the will said his psychological affect was normal. The neighbor that had seen him for long periods of time and knew him for months in advance of this says on the day that he signed it, he's competent. So those are my objective things. The attorney not only says that he's competent, but writes in a letter that says that to your client that your client is taking egregious actions on these financial issues. Now, I get it that your client disagrees with that, but I've got a disinterested third party, at least to some extent, who has a legal background saying that there is at least some questionable activities involved in this. And there's a reason for a man to say, I think you're doing the wrong thing here, daughter. And so I'm going to disinherit you without necessarily having one side or the other unduly influencing them. There's an objective basis for the decedent to have that decision made. Tell me I'm wrong.
Well, I would indicate that at this point, the undue influence already occurred. That when he makes that decision, he's already been influenced, not just influenced. He's been unduly influenced. It's unfair for Mr. Mercer to step in and take this man who's vulnerable to say just the right things to increase his paranoia. So when he makes that decision, he's in a diminished state. He's been unduly influenced. Number two, I would say, if the court looks at this will that stated, there's two wills. One's on December 7th of 24. One's on December 27th of 24. He died before December. So we say, well, no big deal. Now, I've never seen this before, so I think it's a big deal. I would argue that it is. And I would also indicate that I don't like to suspect attorneys of doing anything improper. I've never seen it before, but now I have, and I can't ignore it. Jean Mahalik Weiss is and if the court looks at the transcript of what she's testifying to, I think it's, well, I use the right word, but I think it's important to look at. I think it's suspicious at least, but Jean Mahalik Weiss is one of the witnesses to this will. And it says, we the witnesses sign our names to this will on the date that is first written above, and that is December 27, 2024. So if you're an attorney and you don't realize that your client just signed a second will, why are you signing two wills, by the way? And one of this has the wrong date, that's a big problem. And then the other person who signed it is Cheryl Goff, who testified of all the bad things that Diane did. And if the court looks at that, and I said, Ms. Goff, if you knew that Diane Gilpin didn't do these things, would you have a better opinion of her? Yes. Now I'm paraphrasing. She was told certain things about what Diane Gilpin did. So she thought Diane was the worst person. And if there's no evidence for that, then again, that's someone that's been unduly influenced in a different way, not to use the term of art, but she's been influenced to think certain things about Diane that aren't true. And again, this isn't an easy case that I'm saying it's easy, but if you look at it, this is the case of undue influence. This is the Hornbook textbook case.
Thank you, sir. All right. Michigan statute defines sufficient mental capacity in MCL 700.2501. Says that an individual 18 years of age or older who has sufficient mental capacity may make a will. And subsection 2 of that statute says that sufficient mental capacity requires the following things. A, that the individual had the ability to understand that he or she is providing for the disposition of his property after death. B, that it had the ability to know the nature and extent of his or her property. C, knows the natural objects of his or her bounty. And D, they had the ability to understand in a reasonable manner the general nature and effect of his or her act in signing the will. The comments under that statute indicate that a person with some mental impairment or even for whom a guardian or conservator has been appointed could at the relevant time be of sound mind. The impairment or the presence of a guardian or conservator is not automatic disqualification from making a valid will. Also, in reviewing that statute, case of estate of Jenkins from the Michigan Court of Appeals in February of 2019, number 341005 says that where a will has been challenged with testimony that the decedent was confused and paranoid during times both before and after the will, the court found this to be merely opinion evidence and insufficient to even raise an issue of material fact in the face of uncontroverted testimony, statements of the testator's capacity from the attorney who prepared the will and from medical records contemporaneous with the execution of the will, that the testator was alert and exhibited normal thought content. And then it also goes on to say that an individual is presumed to have capacity to execute a will and affirm summary disposition in favor of the will's validity. Further, in the estate of Michael Gurniak from the Court of Appeals, number 277537 from June 24 of 2008, was a summary disposition case. Summary disposition was allowed. It says that the moving party has the burden of supporting it with affidavits, all the normal summary disposition stuff. And it talked about a person executing a will having testamentary capacity,
Look closely at the screen right now. This is the exact moment the judge's BS detector goes off. In this courtroom, feelings don't matter, only cold, hard facts. Under this brutal pressure, who do you think is lying? Drop your thoughts in the comments.
Same statutory information I just read to you applied in that case as well. It said that testamentary capacity is judged at the time of the execution of the will and not before or after, unless the condition of the testator before or after the execution of the will is competently related to the time of execution. Further went on to say that weakness of mind and forgetfulness are insufficient to invalidate a will if it appears that the mind of the testator was capable of attention and exertion when aroused and he was not imposed upon. A testator may be suffering physical ills and some degree of mental disease and still execute a valid will unless provisions thereof are affected thereby. Circumstantial evidence in this particular case that Gurniak suffered from mild dementia fails to establish any genuine issue of material fact as to his competence to enter into the challenged transactions. In the face of uncontroverted deposition testimony from bank personnel, the Gurniak understood the nature and consequences of the transactions that he entered into them knowingly and willingly. Finally, in the estate of Pauline Runyon from the Court of Appeals, December 17th, 2020, number 350595. The argument was that the contestants failed to overcome the presumption that Runyon possessed the requisite testamentary capacity to execute her will. It is presumed that a testator had sufficient capacity to execute a will. The contestant of a will has the burden of establishing lack of testamentary capacity, undue influence, fraud, duress, mistake, or revocation. And whether a testator had the requisite testamentary capacity is judged at the time of the execution of the instrument, not before or after, except as the condition before or after is competently related to the time of execution. Further, proof of old age, physical weakness, or forgetfulness is insufficient to establish a lack of mental capacity. In this particular case, as to lack of capacity, Ms. Gilpin and her attorney have alleged that from April of 24 through about October of 24, there are varying things that in their minds show that the decedent lacked capacity. Those would include starting to become confused, mistaken appointment in Petoskey in April, was accused in late April, accused Diane of stealing a tray of gold coins and said that there was no tray in reality. In May of 24, accused a neighbor of stealing a garden hose and their dock, and then fell in the water and made allegations that he fell in the water when he was dry. July of 24, accusing Diane of stealing $29,000. Again in July, confused regarding accusing Diane of improperly taking money to use for her expenses. And then July through October, accusing her of other wrongdoings. In my mind, all of those things are, as the cases that I read to you, merely opinions. They do not directly connect to the day of the writing of the will and the competent testimony, deposition testimony, and doctor records indicating that the decedent was of proper legal capacity on the date that he signed the will. Much of the accusations in this case come from Diane Gilpin alone, or very much so from her, and very limited other other influences. And they are contested by the attorney, who says the exact opposite on many occasions. And I don't want to get into necessarily a factual argument about those things, because in my mind, the fact that Ms. Gilpin didn't have any contact with her dad physically since May of 24, when the will was written in December of 24, and then didn't have any contact at all, either by phone or otherwise, from October of 24 on, shows to me that the allegations of lack of capacity are too far out away in time for them to have a concise connection to whether or not there was legal capacity to issue a will in December of 24. And I based my decision in that case on the estate of Jenkins and the other citations that I gave in this opinion already. I think they're too far removed in time because of the lack of context since October and May of 24, that there is no issue of material fact, and there is a presumption of capacity. And then I have the primary care physician in November of 24, late November of 24, saying that there was legal capacity. I have the medical record notation of the doctor that was with the defendant on December 7th when it was signed in the hospital, indicating that there was legal capacity. I have the attorney indicating that there was legal capacity, and I have the neighbor who was the witness to the will, all indicating that there was legal capacity. Given the presumption and that level of evidence and the distance in time of all of the allegations made by Ms. Gilpin and the sons, I don't believe that there is any proper factual issue as to legal capacity, and I'm going to grant summary disposition as to legal capacity. Moving on to undue influence. To establish an undue influence, it must be shown that the grantor was subjected to threats, misrepresentation, undue flattery, fraud, or physical or moral coercion sufficient to overpower his volition, destroy free agency, and impel the grantor to act against his inclination and free will. That's from the estate of Carmi from the Michigan Supreme Court in 2003, quoting Carr versus Hogan from the Michigan Supreme Court in 1976. A presumption of undue influence arises when the grantee had a fiduciary relationship with the decedent. The grantee had an interest represented by the grantee benefited from the will, because of the fiduciary relationship, the grantee had the opportunity to influence the decedent in giving that benefit. A fiduciary relationship is a relationship in which one person is under a duty to act for the benefit of the other on matters within the scope of the relationship. A fiduciary relationship can also exist when one person places faith, confidence, and trust in another person on whose judgment and advice the first person relies. When the presumption is established, there is a mandatory inference of undue influence that shifts the burden of going forward with contrary evidence into the person contesting the claim of undue influence, but the burden of persuasion remains with the party asserting undue influence. And that's from Inmate Mardesian Estate, Michigan Supreme Court from 2018. In addition, on the subject of undue influence, much of the same is quoted in the estate of Peterson from the Court of Appeals in 1991, which gives the same definition of undue influence in the same requirements, the same three requirements for undue influence, saying that there's a mandatory inference of undue influence, shifting the burden. However, in this case, the court held that the question that the court concerns itself is whether or not through this position, that is the fiduciary position, was he able to influence his mother, and that is all right. So from all of that, I deduce the requirement that there be, number one, that there be a fiduciary relationship, and that it is because of the fiduciary relationship that the decedent was influenced to change, or could have been influenced to change in this particular case. Of the three requirements for a presumption, fiduciary relationship, the grantee benefits from the will, and because of the fiduciary relationship, the grantee had the opportunity to influence. I find that there was no actual fiduciary relationship between Mr. Mercer and the decedent. The healthcare power of attorney was not signed until the same day as the will, December 7th of 24. Therefore, there was no fiduciary relationship in that extent. Mr. Prastrink has argued that there was a fiduciary relationship before that, given the connections, the review of the financial documentations, and the alleged opportunity to change the decedent's mind about those things. I do not find that that relationship meets the definition of fiduciary relationship that I read into the record earlier. Fiduciary relationship is a relationship in which one party is under duty to act for the benefit of the other on matters within the scope of their relationship. I find that there was no duty. This was a grandson and a grandfather having a conversation about the grandfather's financial condition. I don't find that the grandson at that time, Mr. Mercer, had a duty to act within the scope of that relationship. This was driven by, in my mind, the grandfather who was angry at his daughter for perceived wrongs that he believed that she did. I believe that that was any attempt, or excuse me, any opportunity to have an undue influence, I believe, was ameliorated by the fact that the attorney who had previously drafted a will that favored Ms. Gilpin then took a look at the matter and drafted a letter to Ms. Gilpin asserting what the grandfather found to be and claiming that there were financial issues. So I don't see any duty on behalf of the grandson. I don't find any undue influence on behalf of the grandson, and no fiduciary relationship occurred in my mind because of those things. The undue influence, I believe, is also negated by the fact of the family friend or the neighbor having access to the decedent on a regular basis in the 6 months leading up to his death and the signing of the will, and believing, consistent with that, consistent with the beliefs of the decedent, that Ms. Gilpin was doing these actions, and it's further negated. Undue influence is further negated by the fact that the grandson was not present during the signing of the will, and was lived a number of hours away, and had less access to the grandfather, and not on a regular or daily basis for that reason. So for all those reasons, I find that there's been no issue of fact that could be found for undue influence, and would grant summary disposition because of those reasons. Ms. Haynes, would you prepare an order, please?
Thank you for your time.
The gavel has dropped. Subscribe to Law Locked for more courtroom drama, and we will see you in the next hearing.